We have a special treat in store for you this morning, a serious discussion of constitutional interpretation and the Bill of Rights, led by two distinguished constitutional law scholars. Burt Neuborne is the Inez Milholland Professor of Civil Liberties at the NYU Law School, where he has taught for many years. Professor Neuborne also serves as the legal director of the Brennan Center for Justice, which is located at the law school. An expert in constitutional law, Professor Neuborne is a member of the American Academy of Arts and Sciences. He received his undergraduate degree from Cornell and did his law work at my alma mater, Harvard. Professor Neuborne's scholarship touches on such important topics as civil and political rights, the operation of democracy, the Bill of Rights, the separation of powers, and judicial review. One of his more recent and, may I say, provocative works, and I quote, "The house was quiet and the world was calm. The reader became the book, reading the Bill of Rights as a poem," end quote, is the subject of today's discussion. I will introduce the article briefly in a moment. And incidentally, copies of Professor Neuborne's article are available in the back of the room. Professor Randy Barnett is the Carmack Waterhouse Professor of Legal Theory at Georgetown Law Center. Prior to entering the academy, Professor Barnett practiced law as a Chicago prosecutor and as an appellate advocate, most notably arguing Gonzalez versus Raich in the Supreme Court of the United States. Also a prolific constitutional law scholar, Professor Barnett has published more than 80 articles. He received his undergraduate degree from Northwestern and also got his law degree at Harvard Law School. Professor Barnett's scholarship spans several areas of law. Most prominently, he has published several books on contract law and constitutional law. Most recently, he has explored topics in the philosophy of law, structural constitutional law, originalism, federalism, and the presumption of liberty. Now, the topic for today's panel is Professor Neuborne's article, in which he argues that the current jurisprudence and scholarship on the Bill of Rights suffers from a separationist flaw. That is to say, the Bill of Rights is currently analyzed amendment by amendment, or even clause by clause, in splendid isolation. But Professor Neuborne argues the Bill of Rights is better read as a structural whole. Professor Neuborne finds that there is a coherent purpose to the Bill of Rights. It is both vertically and horizontally organized by theme, according to the framers' conception of threats to freedom and the Republic. He marshals through historical evidence to support this thesis. And he then discusses its implications for 9th and 10th Amendment jurisprudence and the protections of the First Amendment. Professor Barnett will respond by raising the question of what it means to follow the text. Sometimes judges do not follow the text when they should, and sometimes they say they are following the text when in fact they are not. In particular, Professor Barnett will explore the connection between following a text and following a principle abstracted from a text. But enough of introduction. Let these outstanding scholars speak for themselves. We will hear first from Professor Neuborne, who will speak for 10 to 15 minutes. Then Professor Barnett will offer his remarks for about 10 to 15 minutes. I will ask Professor Neuborne to respond very briefly, if he wishes, and then the remaining time will be spent with discussion, with questions from the audience. Professor Neuborne.
Thank you, Judge O'Scanlan, and it's always a delight to be on a panel with Randy. I particularly want to thank Dean Reuter and Julie Nix for offering the invitation to speak. I never turned down an invitation to speak at the Federalist Society, either at NYU or at other venues. It's no secret that I usually am in profound disagreement with many of your policies, but I have to say that over my career as a law school teacher, there's been no organization in American legal life that's been as committed to the free discussion of ideas and as intellectually open and stimulating as the Federalist Society, and so I salute you for that. The derivation of the title that Judge O'Scanlan mentioned is a line from a Wallace Stevens poem. If you don't know Wallace Stevens and you're a lawyer, you should get to know him. Wallace Stevens is the lawyer's poet. He was an official of the Hartford Insurance Company. That was his day job. And at night he wrote some of the greatest poetry in the English language. Much of Stevens' poetry is about the act of reading, the mystery of reading. And the house was quiet and the world was calm is Wallace Stevens' a great pin to the act of reading, and the reader becomes the book. It's the merger of the reader and the text. And I take it as an inspiration for the work. As the judge points out, current scholarship and current adjudication tends to view the Bill of Rights and the whole Constitution as a clause-bound document. We tend to tear words out of the document and look at them in isolation, sometimes clauses, sometimes just plain words torn from the document itself, and we do the best we can in terms of finding what the meaning of those words are, ranging from originalism to purposism to all of the various isms that we talk about when we read the text. And in some sense, it seems to me that we treat the Bill of Rights as though the founders threw a pot of ink at the wall, and what we're doing is reading the random splatter. And I want to suggest to you that reading it that way misses an extraordinary aspect of the founders' genius. Because one of the extraordinary things about the Bill of Rights is the fact that it has, unlike any rights-bearing document in our intellectual history, if you go back to the Magna Carta and trace them down, it has within its four corners a remarkable structural coherence, both vertically and horizontally, that teaches us how to live in a tolerant and free democracy. And even if it didn't change the outcome of a case, it would change our understanding and our deep commitment to the document if we began to look at it that way. But I think it also helps us decide cases as well. So let me jump in. I mean, first of all, I wonder, just think yourself, have you ever sat down and read the Bill of Rights all the way through? Have you ever read it as a single coherent document? Have you ever read the Constitution as a single coherent document? My experience has been that American law students graduate from law school without ever once reading the document in a coherent, single way so that you capture its ethos. And what I'm hoping to do is suggest to you that there's a great deal to be gained by reading it as you would read a great poem. You would never read a great poem by tearing a word out or tearing a clause out. You would care about the order of the words. You would care about how the poet structured the thoughts, because the ethos of the poem is captured in large part not just by the words, but by their order and their context and their structure. So let me suggest to you that the Bill of Rights, looked at that way, has this remarkable, I believe, coherence. Let's say vertically. Have you ever asked yourself why the Fourth Amendment is after the Second but before the Eighth? And why the Ninth comes where it does, and why the Bill of Rights ends with the 10th and begins with the First. And I'm going to suggest to you that there is a story that not only is justified in history, but in the text itself, that helps you answer that question. I believe that what the founders did is that the First Amendment is first for a very important reason. The First Amendment unites six luminous ideas, in a single text for the first time in the intellectual history of our culture, and orders them in a particular way to describe the tolerant, democratic commonwealth on the Hill that they hoped to found, the ideal commonwealth that they were hoping to find.